Okay, good. We're good to go.
Oh, Delegate She's here.
All right, outstanding. All right, colleagues, welcome to Business Regulation Subcommittee. Briefly stated before we got online that this is going to be more of a information session. We're going to let Laura obviously take the lead today. We have several bills, two of which are fairly hardy bills, two very small, two a little smaller, but I wanted to at least start with the, I guess we can start with the small bills, Laura, however you want to do it. And Delegate Chi, what I told everybody else is today we're just kind of listening. And good morning, by the way. We're just kind of listening and getting our heads wrapped around them. The chairman's made it very clear we are in no rush. We don't have to worry about crossover for his bill. We do have 3 additional bills we're going to listen to, and we'll tag that and figure that as we can. I know the vice chair's bill is obviously going to be very controversial as well as the chairman's bill. So I just want you guys to, at this point, just peruse. Hopefully we've had a chance to review the information. I'm assuming no. And if that was the case, Laura's just going to start talking today so we can get the subject matter in our head. We'll most likely be meeting tomorrow. If not tomorrow, then on Wednesday. And as I said, they're going to be very short notice, okay? Most likely on the floor. If when we find out we have when we get the time, we're going to jump back in like we used to back in the day, because I do want to get our heads wrapped around what we're doing. Nothing is being pressed, I believe, and the chairman is, not forcing any of these bills out. But he does want us to put our time and effort into trying to see what we can do. Okay, so I'm going to let Laura go ahead and take charge, as always, and let us know, which one you want to start first, Laura, and then just knock it out, and we'll be listening. Take notes again, guys.
And feel free to jump in if anybody has questions as we go along. The vice chair has heard this all before with the I'm going to start with House Bill 581 since the chair is giving me the choice. Just start with that, and then we can discuss the 3 sick leave bills. So House Bill 581 is Chair Davis's bill that establishes a number of benefits and protections for essential workers. And those are workers that are employed in specific industries that essentially don't have the ability to telework. So they're being required to report to work during what's defined as an emergency under the bill. There has been a joint House and Senate work group that's met 3 times over the last couple of weeks to start discussing potentially some amendments to the bill to see if anything can sort of be done to help the workers without harming businesses. So I'll try to sort of point out as we're working through the bill as introduced some of the discussion points in the work group. But the work group kind of talked through everything, and then I think is leaving it to the standing committees, ECM and Finance, to work out the details. So there wasn't any sort of firm agreement, I wouldn't say, on the bill, and maybe the vice chair feels differently, but I would say it was still very up in the air as to what a bill might look like. So
are we the lead, Laura, sorry, are we the lead, or who's where I guess it's just an ECM?
It's ECM primary and appropriations is secondary. So Delegate Solomon from appropriations was a part of the work group so that he could have perspective on the impact on the state as an employer. In the Senate, it's only assigned to finance.
Sure. Okay. Thank you.
Okay. So just beginning with the bill, this first section here establishes a special enrollment period during an emergency. This is similar to, you'll remember in the unemployment context, the Delegate Charkoudian's House Bill 1002 established a special enrollment period for people who are unemployed and, say that their information could be shared with the health benefits exchange. Then in that case, they could have the ability to look for health insurance on the individual market. So this bill similarly establishes a special enrollment period during an emergency. So someone who doesn't have insurance can try to find group health coverage. Can try to find individual coverage on the health benefit exchange. There is an amendment from, I believe Chair Davis is actually introducing this amendment, but initially it was from some health insurance carriers that changed this reference. I believe they maintain that there already is a special enrollment period. I think it's actually through May. So that's something I need to look at a little bit more closely, but this provision of the bill is proposed to be amended, as are a number of the others, as I'll point out. This section here of the bill is just requiring, this is the section of the law that says what notice has to be provided on a paycheck and for each pay period. And so we've had bills in the past that made changes to this, the Pay Stub Transparency Act and et cetera. But this is just saying that the hazard pay that we'll discuss a little later would have to be reflected for each pay period on the pay stub. Now getting into the heart of the bill, section 316.01 is the definition section. So it defines emergency as having two prongs. The first prong is immediate threat or occurrence of severe or widespread loss of life, injury, or other health impacts, property damage or destruction, social or economic disruption, or environmental degradation from natural, technological, or human-made causes. And the second prong is or an incident, occurrence, or outbreak that is the subject of an executive order, an executive declaration under a section of the public safety article, or an executive proclamation under a section of the public safety article. In the work group, there was a lot of discussion about limiting the scope of the bill to just a public health emergency, so not covering other types of emergencies. I think there was pretty broad agreement among the work group members that that might be appropriate. So there was also discussion about limiting it to basically the second prong when there's an actual order or declaration or proclamation by the governor that we are under a state of emergency or it's a catastrophic public health emergency. The definition of essential employer is here. It includes the state and local governments as employers. And then essential worker means an individual who performs a duty or responsibility during an emergency that cannot be performed remotely or is required to be completed at the work site. And there was some discussion about the second part of the definition about contractors and subcontractors. So that might be something that needs to be revisited as to how the bill would apply to independent contractors. Just gonna keep on rolling unless anybody jumps in. If that's okay, just raise your hands or let me know. Section 3, I guess I should point out, in the definition section, we received in the work group and now the subcommittee received a number of amendments from different organizations. The Maryland Hospital Association and other healthcare organizations proposed changing the definition of emergency, as did SEIU. On both amendments would sort of limit the scope to be a health emergency in different ways. And then as to the definition of essential worker, the Maryland Hospital Association and other healthcare organizations proposed to limit the definition to an individual, who performs a duty or work responsibility during an emergency that is deemed to be essential by MEMA in coordination with other state agencies. So the discussion there was, we're getting into the different industries that are listed out as being covered under the bill, but the work group discussed, instead of listing out in statute for every emergency who's essential, instead deferring potentially to a federal agency or a state agency to say on a case-by-case basis, for this particular emergency, these industries are essential, and the workers would get the benefits and protections under the bill. So that's generally what those amendments would do. There was an additional amendment from the Prince George's County Young Democrats that would add education and youth service workers and daycare providers to the definition of essential worker. Moving on to scope. So 316.02 is the section of the bill that lays out a number of industries and sectors that would be covered. It's quite extensive. At the end of the list of industries covered, there's a catch-all. So I'm scrolling down to the catch-all now. Here, number 15 is personnel of any other institution or industry ordered to remain open during the emergency. So there are specific industries laid out but really it's any a worker of any employer that the employer has to remain open and the worker doesn't have the ability to telework. Looks like Delegate Queen has a question, Mr. Chair.
Sure. Go ahead.
Quickly before we go through it. So if we take some of the amendments that define the type of emergency worker based on the federal agency, all those definitions would come out. Is that correct?
I would think so.
Okay.
It would just be, you would be sort of deferring.
Okay.
Another kind of interesting, oh, go ahead. Sorry, Delegate Queen.
No, I was saying, go ahead. That was all I had.
Another suggestion that one of the members raised was potentially establishing tiers. So you could say like a tier 1 of workers, perhaps healthcare workers, if the scope is limited to if the bill only applies during a health emergency, presumably health workers would always be essential in those cases. So perhaps those workers would always be covered, but then you could have a second tier of workers that could be either enumerated in the statute or just subject to determination by an agency that they should benefit from the provisions of this bill. We received, I believe, 17 amendments about changing the scope. Of course, you can imagine a lot of industries would like to be taken out of the bill. So construction, there's a SEIU offered a construction provision that says the subtitle does not apply to essential workers who have the ability to complete their required duties by telework. So that would kind of make it explicit that, like, I am a lawyer for the government, but I have the ability to telework most times. So adding a construction provision like that would make it clear that I wouldn't be eligible. There are a number of amendments to take out different industries like hotels, court reporters, self-storage, restaurants. Regarding restaurants, there was also an amendment to clarify that the workers at restaurants are included. That was I think it was the Restaurant Association feels it's unclear whether restaurant workers would be covered. So there's a desire on both sides to either put them in or put them out of the bill. There's also agricultural workers that would like, the industry would like those workers to be taken out. Landscapers, roofers, self-storage, farmers markets, lawyers and law firms, potentially limiting that to those who employ only 2 or more persons. Changes to commercial aircraft, residential service agencies, commuter bus drivers, the energy sector, and the education sector. So pretty much a lot of industries are engaged and either wanting clarification or wanting out of the bill, quite frankly.
And I was going to say, when it comes to like those huge omnibus, amendments, you don't have to hit them all, because what I want everybody to do is get a flavor of, hey, is this moving forward? Because there's no, you know what I'm saying? There's I'm just saying, and I'm just don't want to waste a lot of your time because we're not gonna remember everything. But with omnibus, when you don't have to hit them all, it sounds like pretty much everybody wants to be out the bill if they can. Thank you.
Those are the most of the amendments we received were those specific industries wanting to be out. So I won't be boring you with anything like that moving forward. The next section of the bill, 31603, speaks to requirements for MEMA, the Maryland Emergency Management Agency, or local emergency management agencies. So MEMA or a local emergency management agency has to periodically evaluate and determine whether an emergency is occurring. And then if the agency determines that one is occurring, they'd have to announce publicly in writing, hey, this is in effect, employers need to comply with the requirements in the law. And then when the emergency is subsided, they would have to again announce publicly in writing, this is over now, you no longer need to comply. One of the amendments that we received from the Hospital Association and other health organizations would take that section out. They've proposed kind of changing the role that MEMA would have in ensuring that this sort of new scheme would be enforced. The work group discussed the role of MEMA, and I think there was sort of a desire to say, instead of having MEMA involved, it could be the governor or the state generally making this declaration. But I think that's something that will depend on how you want to define the scope. If you want a specific agency to say these workers are essential, perhaps that's the agency that should maybe be making a determination of when there's an emergency in effect. The next section of the bill, 31604, is sort of general requirements for essential employers. So the section requires the employer to provide working conditions that reduce physical harm and mental distress, ensure physical health and safety. This section also requires the employer to provide necessary amounts of PPE at no cost to essential workers, to create and maintain written protocols to enforce certain disease mitigation measures, and to provide or implement any other measures or requirements to ensure general health and safety of workers. Maryland Hospital Association and other health providers offered an amendment to this section as well that would change sort of the elements of, basically they would change the requirements of this section. There was concern with some of the healthcare organizations as to how this bill would specifically apply to them. So that's something that the subcommittee will have to kind of look at, because we'll get into in the next section, like the right to refuse coming into work for unsafe work conditions. And in the healthcare setting, that presents specific challenges for those employers. So even right before the meeting, I was receiving a number of other amendments from healthcare organizations. So I think they have some specific needs that the subcommittee will have to think about. Section 31605 defines an unsafe work environment and says that if there is an unsafe work environment and an essential worker fears for life or health during the emergency due to the nature of their job, the essential worker would have the right to refuse. So the right to say, I'm not going to fulfill that specific job duty. In order to refuse the work and be covered from it or protected from any adverse action, the essential worker would have to provide notice to the employer that I think it's within 3 days. We're going to get to it. Yeah, down here in D. So the worker has to promptly notify the Commissioner of Labor and Industry within writing within 3 days after the worker becomes aware of the unsafe work condition. And then the Commissioner of Labor and Industry has to notify the employer and may ask the employer to take certain steps to remedy the situation. If the employer doesn't remedy the situation, then the commissioner would have certain enforcement authority, like potentially assessing a penalty. And let's see, the commissioner would have to consider certain factors when deciding whether to and the potential amount of a penalty. Let's see. And then this here requires an employer to comply with any regulations, protocol, standards that the Commissioner of Labor and Industry requires. Let's see. Related to this section, Delegate Valderrama has offered an amendment that would alter and enhance the anti-retaliation protections under the bill. And it removes references to penalties and enforcement measures. That's because we'll be discussing it a little bit later, but Delegate Valderrama has a separate bill, House Bill 124, that required the MOSH, Maryland Occupational Safety and Health, to establish an emergency temporary standard for COVID. And so the work group discussed this, that instead of having employers set up their own plans, which we're covering in this next section here, 31606, there's a way where the bill could instead say employers don't need to set up their own plans. They just need to follow what federal OSHA says or what MOSH says is the appropriate sort of health and safety standards. We got a number of other amendments before I move on to the plan section here. We got a number of other amendments from the Hospital Association, SCIU, to make a number of other changes to the right to refuse section. 316.06 is what we were just discussing. So it requires an employer to set up a specific health emergency preparedness plan for responding to a catastrophic health emergency. The employers have to annually review the plan and submit any changes to the director of MEMA. And then the plan has to include certain information like steps that a worker should take if there's any kind of retaliation going on in the workplace, procedures governing PPE, work hours and shifts that would take effect during the emergency, sanitation procedures, teleworking capabilities, changes in pay and benefits, and any mechanism for notifying a worker that he or she may have been exposed. And then the plans would have to be posted in a common area that's visible and shared with MEMA and the relevant local emergency management agency. As I mentioned, Delegate Valderrama has an amendment that strikes this from the bill and instead sort of requires employers to adopt and follow the emergency temporary standard that OSHA is expected to adopt. And then if OSHA does not adopt it, requires most to adopt an emergency temporary standard for COVID. And then generally, MOSH would have to also set up a general aerosol transmissible standard that would be in effect starting in the fall, I believe, because this bill isn't just COVID specific. This is for all emergencies. So there were a number of other amendments from the Hospital Association and others making changes to the individual plans that employers would have to make. The next section, 316.06, is about minimization of the risk of transmission. So it requires an essential employer to take certain proactive steps to minimize the transmission of an infectious disease, to pay all costs related to testing during an emergency, and to report all positive test results to the Maryland Department of Health following certain protocols to protect a worker's individual identity. And then the Department of Health would have to collect that information and categorize the results by industry and publish it in a way that's available to the general public. And then the commissioner would have to adopt regulations to carry out the section. We've received a number of amendments from the Hospital Association about how this would affect health workers. Specifically, I think I mentioned before about evacuating a work site in a health setting that may not be possible. So we have those amendments for consideration. 316.08, and you guys, thank you for hanging with me. This bill has a lot in it. 316.08 is health and bereavement leave. So I believe this was a topic of discussion a lot at the hearing. So the bill requires an essential employer to provide at least 14 days of paid health leave for illness or health needs related to the emergency, and then at least 3 days of paid bereavement leave for the death of a family member. And there are some construction provisions in this section. So the bill may not be construed to allow a worker to take leave consecutively with earned sick and safe leave, or to prohibit an employer from providing additional leave. So this was discussed at length in the work group about how this is establishing additional leave requirements. A lot of times bills, like we had the bereavement leave bill that the committee already passed that said a worker could use existing leave for a certain purpose, for bereavement in that case. This is setting up a new category of paid health leave during an emergency and paid bereavement leave during an emergency. And that's a little different from the sick leave law, because sick leave has paid or unpaid depending on the employer size. This bill doesn't distinguish based on employer size.
Was it all paid leave?
All paid.
Great, okay.
There was discussion also in the work group about, the health leave, if there should be another construction provision for, like, the federal government, required certain emergency paid sick leave to be provided to workers. And then there was a I think they subsidize that. The federal government kind of reimbursed employers for that. So there's nothing in the bill that says how it would interact with federal leave. So that's something that the work group discussed, potentially clarifying whether that this would be in addition to that, or, you know, whether it would run consecutively or concurrently. Section 31609 is about hazard pay and financial assistance with healthcare costs. So the bill requires an essential employer to provide hazard pay of $3 per hour for workers making less than $100,000 per year. In general, the hazard pay is retroactive to the start of an emergency, but because this current emergency has been going on for so long, the bill contains a provision later on that says in this current emergency, the requirement for hazard pay goes into effect when the bill goes into effect. So it wouldn't be looking back to March of 2020. This section of the bill also requires an essential employer to reimburse an essential worker for healthcare expenses like co-pays, insurance premiums, out-of-pocket costs, transportation costs, and requires an employer to facilitate access to the Maryland Health Benefit Exchange so the worker could obtain health coverage. The bill says that covering benefits under the Workers' Comp Act would satisfy the requirement to help with healthcare costs, and specifies that hazard pay and financial assistance for health costs may not be counted towards an essential worker's eligibility for state means-tested benefit programs. There was a lot of discussion, as you might imagine, in the work group about how hazard pay would work, the cost that would have on businesses, and then the health insurance piece was also, it's a little challenging because of the interrelatedness of this with workers' compensation. So the committee has heard two bills that would set up a presumption that a worker gets COVID like in the line of duty or at the workplace, and makes it easier for workers to get workers' comp benefits. Currently, it's a case-by-case determination that a worker would have to sort of show evidence that he or she got COVID at work, and then in that case, they could get their medical benefits and their indemnity benefits, like their partial wage replacement through workers' comp. So this was something that the work groups spent a lot of time talking about, you know, sort of the best potential way to ensure that workers are getting help with their healthcare costs without kind of duplicating efforts with what exists under workers' comp. So we've got a number of amendments on this, like striking hazard pay completely, changing the retroactivity language, potentially establishing sort of a presumption within this statute, not within the workers' comp statute, but a presumption under this law that would say if you go to work and you meet certain criteria, you're presumed to get it at the job, and then, you know, I guess your health costs would have to be covered by the employer.
And again, employer is any size at this point.
Mm-hmm.
Thank you.
We're almost done with this bill. Section 31610 has misclassification provision. I'm sure Delegate Adams, your ears are perking up on this. This section says that an employer may not intentionally or unintentionally misclassify an essential worker as an independent contractor in order to avoid paying hazard pay or any other benefits under the bill. And then 31611 is enforcement and remedies. There's a 2-year period for filing complaints with the commissioner. The commissioner has to investigate a complaint may investigate on the commissioner's own initiative. The commissioner has to try to keep the complainant's identity private unless disclosure is necessary to move forward with the investigation. They would have to notify a complainant to the extent practicable that they were going to let the employer know who complained. The essential employer has to comply with any request from the commissioner, And then the commissioner would be required to issue an order compelling compliance and authorized to impose a civil penalty of not more than $1,000, compensatory damages, and any other relief necessary to make the current or former employee whole. Each violation is per worker and per instance, and the commissioner is required to consider, again, certain factors when deciding whether to impose a penalty and what the amount of the penalty might be. We got a number of amendments on this section of the bill to, for example, like shorten the time period for complaining to like 24 hours is what the Hospital Association and other health groups suggested. Suggestions to change the statute of limitations, to change the damages section of the bill. And then I think that's it. That's it. Essentially, we did get a number of other amendments that I didn't go through point by point, but
That was a pretty narrowly tailored bill. And colleagues, the reason, again, I just brought this up is because that's a big monster that I know I see some good in it. And I think that it wraps in a lot of the other bills that we've been seeing. So I can't just abandon it. There are some things that I was looking at Seth's space and Chris's space, I could tell were devastating, and they're pretty painful for me as a business owner too. So I just wanted you guys to hear it. We're probably, if we don't meet tomorrow, we'll be meeting Wednesday and Thursday, most likely Friday, when we can. I wanted to, Laura, you're in tomorrow, right?
yeah, I can be in any day.
You don't have to be in. I'm not trying to violate some law that we probably passed.
Not violating anything.
But because no, I want to create, just try and create a breakdown, like for each section of what we're at, what the ask is. And then we have amendments, and I don't want you to have to retype all those, so don't worry about that. But fudge, we have to at least address them at some point. I just want everybody to hear this bill real quick. If we could go ahead to the vice chair's bill as well, and also with the vice chair's bill, because I don't remember the hearing, what predicated that bill?
It was also the COVID. The advocates that came and asked me to put it in. Brian Feldman has it on the other side. The hearing actually on the Senate bill is tomorrow, I believe. And to be honest, Senator Feldman and I narrowed it a great deal from what they wanted to put in. They sort of wanted to kind of for lack of a better word, it's not litigate, but redo lots of things. And Brian and I both said, no, we're going to limit it very severely to sort of what the pandemic caused. Now, the biggest piece that Laura can go through is applying it to the whatever, but it does expand it to part-time workers and to the farm workers. But I think what we were really trying to do, because I think if we do anything with it, and again, you know, we can work from 581 or whatever, but it was really just trying to indicate that sick leave can be used for a pandemic and that there should actually be additional days available given, you know, I mean, everybody at the time this was drafted was working on you have to quarantine for 14 days. Now, as we know, the advice changed and eventually it was you need to quarantine for 7 to 10. So, you know, my recommendation for this as well as for the other bill is I think we have to do some of the amendments that Laura talked about with 581, where it's really more general in that, you know, directing the businesses have to follow the directions from MOSH or the federal government or whatever the case may be. And I think that's the same with this. If we got to a point, and again, I'm not wedded, that we were going to do something with the Healthy Family Act to expand the amount of time that someone could take off, it would be in conjunction with direction from the CDC or whoever the appropriate people would be, and not just a blanket 14 days, which was the recommendation in January. It's not anymore.
Right. I just know, and I know we'll go through that briefly because I had some questions just from my firm. I think you're known as well, because I know, you know, I was sending people home for 14 days, 3 or 4 times because they just came in contact with somebody. Luckily,
yeah, we did too.
They were able to work from home because financially I couldn't afford to replace it. But I'll let Laura go through the bill because I'm assuming I'm assuming everybody else did, but again, colleagues, we're just trying to go through and get our minds wrapped around it. So if Laura, you want to go ahead and shoot?
Do you want me to go to the vice chair's bill and then close out with the others, or?
Yes, please.
Okay. So the vice chair's bill is House Bill 1326. Let me scroll down. So as the vice chair mentioned, this bill makes a number of changes to the Maryland Healthy Working Families Act, which is our sick leave law. The first couple of changes expand the scope of the law so that additional workers would be entitled to earn the sick leave. So that is individuals who are employed in the agricultural sector or at an agricultural operation, individuals employed by a temp services agency if the agency does not have day-to-day control over the work assignments and supervision of the individual. A separate exemption for an individual who is directly employed by an employment agency or to provide part-time or temporary services to another person. And then the last exemption that's being repealed is to individuals that are called to work by an employer on an as-needed basis in the health or human services industry. These are I think they were called PRN workers, nurses who essentially can make decisions about when they want to go in and when they don't want to be off schedule. The bill also expands the definition of family member to include a child of the employee's domestic partner or an individual who is recognized as the employee's spouse or domestic partner.
Is domestic partner, what's the legal definition of that? We don't have, because we don't have the DC thing with the 7 years, right? Of common
No,
law.
we do not. We don't
Right.
have common law marriage. So
So
we'd
domestic
have to have
partner-
signed a domestic partnership agreement in order to be.
So there is domestic partner agreements in Maryland. And are they
Yes.
recognized as marriages as far as in the?
No.
Oh,
Not as a marriage, just as a contract indicating how they're sharing expenses, perhaps, how they share title to things.
and can it be gotten out of as easy as is it difficulty? Is it like a divorce or is it just, hey, we're done?
It's usually there are clauses in these agreements that talk about how to terminate.
Good boy. All
They're
right.
very seldom used now that we have civil marriage.
Right.
but-
Okay.
You saw more of them before we had civil marriage.
Okay.
Okay. Let me go back down. And then family member would also include any other individual related by blood to or whose close association with the employee is the equivalent of a family relationship. And then the bill defines healthcare professional and public health emergency and public health officer for this health leave that's going to come later in the bill. Let's see. This section is the part of the law that lays out the leave generally, the earned sick and safe leave requirements. And so this here is saying that except as provided in the public health emergency leave section, those are the leave allocations. So here it's making clear that that leave is in addition to the regular quote unquote leave that an employee would be able to earn. But it also says here that that leave, the regular leave, may be used during a public health emergency. So you could use it for that. You could use the leave that you've earned for that purpose, but you don't have to be made to use that first. You could use the leave that has to be provided. Is that correct, Madam Vice Chair? How that
Yes,
would
you're right.
work?
Mhm.
Okay.
Yeah, that's correct.
So this is the section that sets up the new leave requirement. So on the date that a public health emergency is declared or proclaimed, each employer shall provide each employee with paid earned sick and safe leave in addition to the leave provided, like the regular leave, in the following amounts. So full-time workers who regularly work 40 hours or more per week would be entitled to 112 hours. And then there's a sort of a calculation for workers who regularly work fewer than 40 hours per week. Let's see. The bill says that the leave would need to be provided one time during an emergency. So not even if, in our case, this current pandemic, the state of emergencies and proclamations have continued to be extended. So here it says it's one time, not each time that something gets extended. And let's see. The leave that's provided for this public health emergency could be used during the emergency and 3 weeks after. And then section C here talks about the allowable uses for the leave. So like to isolate without an order to do so because the employee's been diagnosed with a communicable disease or is experiencing symptoms, to seek or obtain medical diagnosis, care, or treatment because the employee is experiencing symptoms, or preventative care, to care for a family member who's isolating due to determination by a public health official or a healthcare professional that the employee's presence at work would jeopardize the health of others, to care for a family member due to that same determination, due to the employee's inability to work or telework while subject to a stay-at-home order, due to the closure of an employer's business, to care for a child or other family member for certain reasons, or due to the employee's essentially pre-existing health conditions that make the person more susceptible to the communicable disease. And the employee here says is allowed to use this leave that's provided before tapping into the regular leave that the worker has earned. Says this is the notice provision. The notice needs to be provided as soon as practicable, only if the need is foreseeable and the place of business has not been closed due to the public health emergency. Employer is not authorized to require documentation. That's different from the just general sick leave requirement. And let's see. Employers have to provide notice within 7 days after a public health emergency is declared, so workers know that they would be entitled to take this leave. And the notice would need to be provided every 3 months if this continues on. And it would need to be sort of language accessible. If the Commissioner of Labor and Industry makes sort of model notices in different languages available. These are just sort of some conforming changes. This section 3 here says that if a public health emergency was declared or proclaimed due to COVID remains in effect, the employer has to provide the leave on the effective date of the bill and apply paid, earned, and sick and safe leave retroactively for employers employed on the effective date. That part right there, that second prong, I wasn't totally clear on what the intent was behind that. Whether I wondered if that was to say if someone needed to quarantine last July, that this leave would be retroactively applied and then the worker would get that pay. I wasn't sure, but I thought maybe.
I'm not sure either. And in my humble opinion, I think all of the retroactive provisions in both 581 and this one are problematic. And we probably should really do anything that we're doing prospective.
That is 1326.
Good job, man. Again, guys, that's another big one. Obviously, we could take provisions out of one bill, put them in the other. We could figure out how to wrap this around somehow. And the goal is, I really do believe we have to do something. All right, now what we do is up to us, but I believe we have to create some sort of work product. So this actually is, it's not just about, and this is for my conservative friends, I guess myself included, is that we have to do something. You know, what we do. So it's important that we create a good work product. and that Chris, you, Mark, Seth, something's going to come out. It's just what comes out, and obviously keeping the employers in mind. So with these two, I just want you guys to wrap your heads around them. We're probably going to meet on Wednesday again and start going over the bills. I'm trying to take the pieces out because since we have two fairly big omnibus bills, just taking the pieces out of, getting the pieces all set aside so we know, so we can figure out what's important, what's salvageable, what's important, and then what we just, we're not gonna be able to wrap our mind around. So that's the next goal. Okay. I know we have two more small bills, right?
Mhm.
We'll hit those real quick.
Sure. So House Bill 350 is Delegate Adams' bill that again relates to the sick leave law. You'll remember that sort of the general rule under the sick leave law is that an employer may require verification that leave is used appropriately if the worker takes off more than 2 consecutive scheduled shifts. The sort of special rule under the current law is for leave taken between days 107 to 120. That was put into place to protect against employee abuse of leave for, the example was provided for workers potentially in Ocean City taking their leave right at the end of the season and leaving an employer in the position where you can't cover the shift. So for that case, if an employer agree in writing at the time of hiring about verification being required sort of during that last part of employment, then the employee needs to comply with that. Otherwise, the employer can deny a subsequent request during that time period for the same reason. So if a worker says, I'm sick today, I have a fever, and they had already agreed that they would provide verification that they went to a doctor or something, even though it wasn't more than 2 scheduled shifts. If they don't provide that verification, then the next time they call in a week later and say, I have a fever, the employer could deny the leave request. So what Delegate Adams' bill is doing is changing the leave under that special rule for the seasonal workers. So it alters it says that instead of the employer and employee agreeing to verification during that period, an employer would have to provide notice that they're going to be requiring verification. And then the employer would be allowed to deny a leave request if the employee doesn't provide the verification. The sponsor is in the subcommittee, so he can also speak to this, but this is a version of an amendment that I received from his office, and I understand there may be an updated version, but it would sort of make further changes to this special rule for seasonal employment. Mr. Chair, perhaps Delegate Adams could speak to that a little more about his intent.
Yeah, Chris, clearly this bill is geared towards seasonal employees. Is that correct?
Right. So, the Senate had their hearing. I think they're sort of waiting for us to move this bill forward before they act. But I think there's general consensus with additional amendments that create enough protections for the workers, at the same time give the business owners some, leverage in the conversation. So in layman's terms, what this amended version of this bill does is at the time of employment, CT, if I hire you, you and I'll sit down and we'll go through the policy and we'll talk about a form, that you'll need to fill out. You'll see that form before you're hired, and provided you agree with the nature of what we're asking for, between 107 and 120 days, you come to work for me. The way it works for seasonal employees is they earn the sick and safe leave when they hit 120 days, but the seasonal exemption only works if you can go the full 120 days. So there's this basically a 14-day window where this bill would apply. If an employee starts sometime around Memorial Day, ends around Labor Day, you imagine that maybe an employee would take off time that they've earned during the summer, right during Memorial Day. And so that's the nature of the bill. They're not saying you can't do it. And we're actually getting rid of this in this bill, the verification part, and we're just calling it a certification. So it's a good faith acknowledgement by the employee that they're taking this leave for a a legitimate purpose under the law. The mechanism to prove it is not there. It's primarily to help the employer engage with the employees so they understand that this isn't a free-for-all before you go back to college to take a long weekend or Memorial Day, which is how it's being abused right now. So I'm hopeful that the committee will take the amendment, because again, we're only talking about a roughly 14-day, well, it's a 14-day window. It really only applies to employees that are seasonal in nature. This isn't for full-time work. And, the easy fix would have just to have extended the provisions of this law to 120 days, not 106. And I would gladly accept that amendment if the subcommittee chooses. But considering we would lose that argument, all I'm asking is that not a verification, but merely a certification at the employees' good faith of when they sign the certification that they're out for a verifiable reason. The employers believe that this is enough leverage in the conversation to make sure people just don't broad stroke leave at the end of their work season.
Okay. And what was, again, we'll come back to this one. I think we can talk a little more, have a little more discussion. I'm sure there was some pushback. I want to hear what that is. Let's move on to the next bill.
The last bill is House Bill 909. This is Delegate Carey's bill that essentially exempts substitute teachers from the sick leave law.
Yeah, I saw that one. All right, guys. Just before we adjourn for today, does anybody have any questions? Pam, has your hand been up? I'm sorry. Delegate Queen?
It just went up for questions. Your statement, I was going to ask a question before we left.
No, just that we're gonna I'm gonna talk with Laura tomorrow and try and lay out something to simplify all the little pieces of the two big bills to see what we can pack together in one bill. I guess we'd be working off the chairman's bill, I would assume, and just what pieces from the bills we can add in. Obviously, we'll have conversations about the other two bills as well. Delegate Queen.
Just a question for us to think about when we come back to look at this, something that some of my old management friends have been asking, especially listening to this, especially around hazard pay. When and how are we deciding an emergency is over? Because I'm not quite sure. I've heard, we're still in COVID, we're still in this emergency phase, but now you have the governor, opening up things. Is that the definition that we're no longer in an emergency? How is that defined? I think we've got to think about how is that defined. Not answering now, but that's going to be a question many managers are going to ask you, especially on the corporate side, because you're telling them they got to pay hazard pay for this time period. When is this emergency ending and who defines that?
And I'm fairly certain that there is a true legal definition for that and answer, because I believe when you're a state of emergency, you're eligible for federal funds, things like that, like floods and things. Right. So they have a beginning and an end. So there is a legitimate legal definition. And I think the governor is the one who calls it when the state of emergency is over. I can't predict when this one's going to be, but it's not something higgledy-piggledy where people get to feel like we're doing better. It really is a specific time when they'll say the state of emergency is we're no longer in a state of emergency, because his powers increase with the state of emergency. The governor's powers, he gets more powers. So yeah, doesn't just dissolve gently.
Understood. But there should be, again, where do we go? We go by federal doing it, or do we, we need to talk about that, because you can have a governor going rogue and say, I'm never going to declare it's not an emergency, it's over.
And also, I'll say this, I don't see a lot of appetite for this, the hazardous duty pay. That's going to be a huge mountain to climb. So I would not get wrapped around that. That's what I want you guys to do. Let's assume that might not be in there. Then what are we going to do? That's probably the best way to look at this, because I'm not giving my personal opinion, but I'm saying, I know that's a big ask, but there are other things in there that are of value, and I don't want that to be the poison pill, the thing that slows everybody up on this. All right. So, we have the biggest things I see are the hazardous duty pay and the extra leave between the two bills. And, as an employer, I'm like, well, who's paying for those? And that's where we have to figure out, how do we lay it out? Or do we say, yeah, we can't give you 14 days, we give you 5 extra leave or 5 or 7 in emergency, but you have to use your personal leave first. There are ways we can do it, because the goal is to allow these people, when they're by no fault, they don't have to quarantine. Well, we still want them to be able to have sick leave. Yeah, I can't, and I'm a
I
business
agree
owner.
with that. We
But it's
have to
painful
have
for
that.
me to say, because I have to do it. But also I've got to be legitimate about it. So, I don't want to throw the baby out with the bathwater, and I really need Chris and Seth's help, because we've done this before, guys, on sick leave. Remember, you put your teeth marks into this. I don't want you to like it, but I really want as critical and as constructive of thoughts as I can for the business side. Well, what can they survive? What can they tolerate? Everything I know is a killer. Everything's a deal killer. But if we pretend it's not, what could we deal with? What's helpful versus what is truly a hindrance?
Madam Vice Chair and I were on the work group, and she'll attest to the fact that I was very vocal at the work group, and trying to be constructive on a bill and try to find consensus. Well, Laura was at it too, but I'm sorry. Trying to find consensus where there's such broad policy making. I could quip and make a joke here. I could vote for a summer study on the chairman's bill.
That's good. But and I know you're not going to vote for it, but there are still things.
I said that with tongue in cheek, but
I know.
but the point remains, you're asking a lot in that bill, and to try to cover the turf in the next handful of weeks is
Remember, not a lot has to come out, but something has to come out. The goal is, like I said, I got but that's why, to me, having you guys on is so important, to give some, to chop away at the edges. And, again, it's like the sick leave bill. If we can't do what you want to do, well, what can we do to make it a little more tolerable?
How many years did we move on that sick leave bill before we actually passed it?
Yeah, we've only had a pandemic.
Point of reference.
We've only had a pandemic for about a year. We can't, wait another few years on that. But I get you. I understand. So I'm just saying, and have patience.
Yeah.
But I want to.
And I do think, I'm sorry, go ahead.
Go ahead, Madam Best.
I was just saying, and I do think that Chris was vocal, but at the same time, so was I, as someone that also runs or, makes payroll every week or whatever. And, just as Delegate Wilson does. But, I think the general sense was, if we can provide in 581 direction and, some of the specificity that's in it is, we can't identify the industries. And I think, sort of saying, and I don't know what the next pandemic's going to be. It may be, in one specific kind of industry that a state of emergency is called, maybe, and I don't mean to pick on them, but the poultry industry, by way of an example. And if that's the case, then whose guidelines do they follow? And it would be, OSHA or MOSH or whomever the whatever. So I think the general consensus was, we need to provide direction, but maybe not the specificity. And part of it is, the specificity, particularly in 581, is problematic on the different, what's an unsafe work environment? Okay, well, I think somebody's going to tell you a hospital or a medical care facility in a pandemic is an unsafe work environment. And yet we sure as heck don't want our healthcare providers not there. Chris noted, it talks about evacuation. Generally, you can't evacuate a hospital, unless it's a flood or a fire or something that you have to physically move them from a building. So I think, the bill should provide some direction. We've got to take into account, how it affects medical providers versus teachers versus, first responders. So it's a pretty, at least this year, if we provide direction, maybe there's a little bit of a study at the end of it, but I agree with Delegate Wilson. We've got to put something together that.
Yeah, and that's what I'm saying, guys. I just want you to have it wrap around your head. We're going to do something.
Mm-hmm.
And, and Chris, Seth, you guys know what that means. That means I just need your little brains at work. You guys are good about giving counter arguments. So I'm asking you to stop, but that's why we're going to try, and myself and Laura lay out all the pieces of this puzzle so we can figure out, okay, what needs to be in and what doesn't. And then we can narrow the pieces of the puzzle. So guys, I really appreciate this first attempt at this monstrosity that both the vice chair and the chair have created. Thank you. And we will definitely get back with you guys by Wednesday. I'm hoping to meet again on Wednesday. Laura will set a date. Yes, Chris, you look like you have something to say.
Nope, I'm all good.
Didn't know if that was just an angry outburst. Okay, I got you. But I really appreciate everything you guys are doing. I know this is gonna be a little bit of a heavy lift, and I know, as Chris said, feels like we're kind of rushing and jumping through hoops, but this is our only shot at the pandemic this year. God willing, we're not in the same position next year. And if we do this right, we hopefully never have to see this again, period. Well, Chris dropped off, so I guess it's time for everybody to go now.
Yeah, I got another meeting. Yeah,
And we'll see each other soon, guys. Take care. God
Okay.
bless.
okay.
Thank you.
All right.
See you later.
Bye-bye.